So I'll just introduce myself real quick so you know a little bit about my background. I'm a business attorney. What I do mostly is help people with contracts of all kinds. So if, let's just say you're starting up a business and you need to form an entity, you've got somebody put a contract in front of you. You've probably already seen some contracts. Your students, you live in apartments or something along that line, you have to sign a lease. Well, I review leases for businesses when they're going into retail locations. I also do partnership agreements between different companies that want to get together. There's a thing out there, concept called founders agreements. Those are basically partnership agreements, but they're typically used by startups in just initially getting themselves together, making business arrangement among the 3-4 founders that are involved, so that they have an idea of where they're going and what's going to happen as they develop their project. In addition to that, I help my clients get trademarks, do copyrights, franchising, licensing. I've worked many years in the restaurant industry, so I know a lot about the hospitality industry and how it works. And some of the things that I'm doing right now is I'm actually getting a restaurant in Winter Park. We're getting their liquor license. I've been running around getting all of their restaurant license, their sales tax licenses, getting their approvals for zoning and things along that line so they can get up and open hopefully very soon. So those are the kinds of things that I do. What I think what we said the topic was today was to talk about trademarks, talk about copyrights, and to talk about business startups. And so I'll kind of give you an idea, real quick rundown of what each of those things are, and then we can hopefully at that point, each of you has a project going on. You might have a question in regard to any one of those things, and just start asking questions, and we'll kind of work our way through each question and help you understand what's going to be happening in your world as you get out there and you start operating your business. A trademark. What is a trademark? Trademarks are basically just adjectives. They're words that are used to describe a service or a good. They're intellectual property, but if you think of trademarks that are out there, McDonald's. Well, McDonald's is a hamburger, and it is a restaurant. And when you say McDonald's, you're actually using an adjective to describe a restaurant. Okay, that's a good example of what a trademark is. It's just a kind of adjective, but it's one that's well known. And then you can use that well-known adjective then to describe many other things. So like an adjective or a trademark that kind of got lost in the shuffle was Xerox. Xerox was a company that made copy machines. And for many, many years, and I don't know if many of you still use the word, but people say, well, go Xerox that for me. Well, Xerox was actually a trade name, a trademark at one point in time, but because they didn't properly police it, it became a common word, and so that adjective, Xerox, came to mean the actual thing, a copy. But again, those are examples of trademarks, they're adjectives. Copyright is the next topic that we're going to look at, and when we talk about copyright, again, it's a piece of intellectual property, but when you sit down and you create something, and for that matter, you're writing notes right now, right? You created the notes that you're putting down, unless you're taking down my words verbatim. What you're doing is you're creating something yourself. You're writing it in your book, or you might be typing something out. You might be thinking of or creating a drawing or a sketch of some kind. As soon as you put that idea to some physical form, you own the copyright. It doesn't have to be registered. It's something that the creator owns, and they own it for their lifetime plus many years after that, and it can extend for long, long periods of time. But the issue there when you're talking about a copyright is something that you're creating and that you own because why? Because you created it and it's your copyright. So an interesting thing to talk about is this young lady, Marianne or
Anne-Marie.
Anne-Marie. Anne-Marie does graphic art. And if you hire Anne Marie to do some graphic art for you, guess who's going to own that copyright? Anne Marie's going to own it because she created it. And the thing that you have to do if you're going to hire her to do something for her is you've got to get her to assign her copyright ownership of the thing that she created over to you so that you can use it. And it can get very complicated after that point in time as to what kind of things can be and what type of rights you might be able to get via an assignment. But that's the concept behind copyrights, is something that's been created by an individual, and that individual gets to own that unique thing that they've created. When I say unique, in copyrights can be pretty easy. If I write a text about a Shakespearean play, and you write a text about a Shakespearean play, and we can both call them, the study of Merchant Venice. But they're going to be different. They're not the same thing because there were different creators involved in writing that essay. So there are distinctions when you start talking about copyrights, is that I can be unique in the way that I would write something, and therefore I can get a copyright in what I've written. And you could also get a copyright, and as long as it's not pretty much verbatim what I wrote, as long as you didn't copy from me, you didn't plagiarize, then you can own your own copyright in that work that you created. The final area that we can answer questions for, and you can, of course, you can ask all kinds of questions of me, but we're going to look at what do you do to get a startup, your business going. And there are a number of different ways in which you can start up a business. Some of the ways are you do it yourself, you're a sole proprietor. You don't have a business entity, you just have yourself that's involved. This next step up is you form a partnership. You've got more than one person involved in doing something, and you're kind of adding, each of you giving something to a project, and you're creating something that's the two of you have worked on, or four of you, or five, or half a dozen of you might have worked on. You become partners. We take a step up from partners, and then we typically would go into then a legal entity, which would be either a corporation or a limited liability company. Those are business entities which are formed basically for what the first one was called limited liability. And the good things about limited liabilities is that if somebody sues, then potentially you're not going to find out that they're taking your house away from you. But it also puts you in a position that your tax basis on how you're going to be taxed on things, what kind of expenses you have, also have a different life and a different expectation. Corporations are slightly different from limited liability companies, but they're where you own shares of stock in something. And there are some, again, benefits to that, especially if you're out there, you're creating, you want to get some venture capital into your business. You might want to, your venture capitalist might want to see your startup being a corporation in which shares of stock can be issued and converted into equity interest and things along those lines. So those are a few of the things that we're going to talk about. There's lots of basics that go into each one of those. And so, anybody want to start off with a question they have about any of those things? Yes, sir.
Trademark. So I've been on the USPTO.gov website, watched through a lot of their seminars and everything. And I remember them saying that you should have an attorney with you throughout parts of the process. Is it a necessity to have them there throughout the entire process, or just when you're getting ready to start submitting forms and making sure everything is kind of good to go so you don't get rejected? Since it's
and the USPTO recommends that you have an attorney help you fill out the application so that you fill it out correctly. Because when you pay the application fee, you don't get it back.
Right.
And if you haven't filled it out completely and correctly, although there's a lot of leeway that they will give you, you lose your money. You have to start over again, and you have to pay another fee on top of it. So that's kind of where the warning comes in that you see throughout the PTO site, is that they just don't want you to make a mistake because they don't want you to pay them 4 times for something that if you hired an attorney, you'd only have to do it once.
Is there, like, So they suggested that like you have, so like as an attorney, you would go out and we say that we want to try and trademark this name, and then you would go out and search it. Do you use anything outside of searching just their database?
Right. Well, when you, let me tell you what I recommend to my clients, and that is they do their own search to start off with. And not only do you go to the USPTO and do their search, which is up to about good for the last number of years, maybe about 60, 90 days old, and see what you find out there based on the product that you have, and is there anybody else using that name or similar name. But probably the better searches are you do Google, you do Bing, you do Next, or you do any of these, do all of these other searches to find out what's out there in the world. Google something and find out, who else might be using this, and when you see the word come up or a variation on it, you just track it down, see whether or not it's within, the type of thing that you're going to sell, and whether or not it looks like it might be a conflict. The issue is confusion.
Right.
And what we want to do is we want to avoid there being any type of confusion when we're talking about a trademark. And that's what the searches do, is to see whether or not there's potential for confusion. I had a client recently, and in fact, we got rejected our trademark application. We knew it was probably going to happen, but we wanted to try and see if we could slip something through. We couldn't. He was willing to pay for us to do it that way, but we knew there was a restaurant in California that was using a name very similar to what we were using. We couldn't argue our way out of it with the examiner, and so they said, no, I'm not going to allow you to trademark. Even though it was a different setup, it wasn't different enough. And from his standpoint, even though this one restaurant was only in the California area, it was already trademarked, and he said, I think it's too similar. People might think that you are them, and now you're going to. So again, those are the things you're going to do from the standpoint of doing that search. And you do that search before you do your application.
Yeah.
Regarding what we're talking about with Xerox, so they didn't do their paperwork correctly and whatnot. My product uses a lot of Velcro, for instance, and Velcro, it kind of became the name of like the actual process of Velcro. Everyone calls it Velcro. But Velcro is actually the brand name, and they have different hook and loop systems. And for me, I need to in my product description, I need to use Velcro. Should I be careful in infringing Velcro's trademarks and whatnot by using their actual name, or can I use that name because it's already commonly known for that application?
Right. Well, to the extent that Velcro is trademarked and you're using a product that is similar, then no, you probably shouldn't use it. Now, does that mean that you couldn't compare your product, which should have its own separate name, to better than Velcro? Yes, you probably can do something like that. But just whether or not Velcro itself now would be considered in public domain, I don't know the answer to that. I mean, that would be an interesting project to look up, and potentially you can again Google, go online, and look to see if you see anything where the lawsuit Velcro, and tie some of those words together and see what you come up with, the Velcro and infringement. And you'll see whether or not there's stuff out there, whether or not any court's decisions have said, no, Velcro is now a common term, and therefore anybody can use it.
Do you believe that, for instance, if my product is actually using Velcro brand product, then can I add to the description, let's say, uses Velcro brand?
You'd probably want to go ahead and get a license from Velcro to use it, and in fact, more than likely, if you're using Velcro, you want to go directly to the manufacturer, and they will more than happily give you a right to use it if you're buying the product from them, and you'll be able to buy the product from them much cheaper than you would if you're buying it commercially.
I have two questions actually. On campus, they have like a graphic sale where students can produce images and then sell them. And I know you said that if I make it, I own the copyright. But if I sell it to them, does that customer now own the copyright to that image, or?
It's going to what that purchase and sale agreement said. And if it does not, in fact, say that you are selling them your rights, your copyrights into the product, all they bought was the right to use that image, and it could be, you can limit their rights to use that image in many different ways. I don't know exactly what your site says and what its terms of use are, but from a practical standpoint, unless there's been an assignment of the copyright, you still own it. But we'd have to look at the site, what the terms of use say, in order to make a determination as to whether or not you've transferred your ownership. But typically, that's not done without you'd see a written contract that you're going to have to sign.
And we call those assignments. It's really critical for those of you that are building brands and you want to own your logo graphic, you want to own that avatar they're making for social. Actually need to get an assignment of that, not just pay the graphic artist.
That's right.
You actually must own that asset as a corporate asset. Okay?
And so I don't know what your site is doing, but if you haven't signed something, then it's unlikely that you've given up your copyright.
Well, this wasn't a site, this is just like a physical, like they have a stand where kids, like, college kids come up and they purchase it just like that.
No, they're not, all they bought was a picture.
Okay, and then my second question was, if I make a logo, like if I do start my own brand, I create my own logo, do I need to, that's something I would need to like register if I'm using it like on a larger scale, or?
No, I mean, if it's going to become a trademark,
Okay,
then yes, you're going to want to register it with the USPTO. But if you're not going to use it as a trademark, I'm not really sure how you're going to use it, then no, you don't have to. Typically, registration of a copyright scenario is only done at the point in time where you are in fact going to start licensing or selling copies to other people. You want to go ahead and register, get your copyright, put your copyright notice on it, although that's not required these days, so that anybody looking at it knows that they can't copy it without getting your permission. Yeah, you have a question?
Yeah. When you go to a graphic designer and you purchase that, what would be the forms what are forms of a transitioning, or I guess passing of ownership of?
Okay, well, it's called an assignment of copyright.
Okay.
Right? You can find probably all kinds of examples on the web. When it becomes, what I have done many times is I go into the USPTO site and I look through their records, and they have records of millions of copyright assignments. And I look to see if there's one in there that I think is particularly good for my client's particular product, to make sure that I've covered all the bases that are involved. But it can be as short as 2 or 3 sentences. It can be several pages long. It's according to how thorough are you going to be in making sure that you're getting every little piece of ownership out of the creator and into you. Yes.
To kind of reiterate what you said, it's not necessary to copyright a logo until you start selling your product. Is that kind of what you're saying?
All right. Well, it's not. Copyright is a registration process. I mean, you own the copyright as soon as you create it.
Okay.
Now, the question is, people are going to look as, if you've got a publisher that's going to take your work, going to do something with it, they're going to ask that you copyright it, or they're going to request that they get copyrighted on your behalf. I don't know what the prices are now, so typically $35. You fill out a form, send it in, pay the money, and you get back a nice certificate saying it's been registered. But that in and of itself doesn't do anything. It's just something from a business standpoint people typically do, because we now have federal laws that then start protecting them. So if somebody came to me and said, Joe Blow is copying, something I created, what do I need to do? I'm going to say, first thing we're going to do is we're going to register your copyright. As soon as I get it registered, I'm then going to, and actually simultaneously, I'm writing a letter to whoever is infringing upon it and demanding that they cease and desist. And then once my registration actually goes through, I can file a federal lawsuit for thousands of dollars in damages if they continue to use my copyrighted material, but I have to have gotten that registration in order to file the federal lawsuit to get damages. And that's one of the reasons why people, you don't really need to do the copyright until it becomes a problem with some kind of contract.
Right, so this involves basically like business names, logos.
So business names are they can be, under certain circumstances, copyrighted, but more than likely, no. A business name can become a trademark, but although the distinction between copyright and trademark, there are certain points they start to meld together where you want both of them, but they're not necessarily, and they really are intended to be distinct. IP, intellectual property rights and ownership, between trademark, using that word to describe a kind of service or product, versus a copyright, which is something that is creative that you've done over here. A business name in and of itself is not necessarily going to be trademarkable or copyrightable because it's not necessarily creative.
Okay.
Yes.
Okay, so I've gone up and I've like looked through the USPTO database and everything, and there's like, for instance, there's a company called Midlands, and they do like some sort of insurance thing that I was looking through, and they have their textual logo, or the trademark. They have the iconic logo trademark, and then they have the icon and the text. They have like a synthesis logo trademark. Would that mean that, like, so for mine, if I wanted to put the iconic logo and then I had a text underneath it or to any of the sides, would I have, so if I had it to one of the four sides, would that mean that I'd have to copy or get it trademarked 4 times on each side, or I just trademark it once and then I can use it in relatively any orientation?
The best route to go is you trademark each of them separately and in combination as you're using them. Here's the thing about trademarks. You have to actually be using them in order to get a registration. So that if you put, let's just say you have a product, Coke, right? So I want to get a trademark for Coke, for Diet Coke, right? So I can use this as my sample of how I'm using it. If I just used Coke and didn't put Diet on there, I don't have a trademark for Diet Coke. Did somebody else come along and create, say, oh, I'm Diet Coke? Well, probably not, but the idea there is what are you actually using? And here they're actually using Diet Coke. So they have, I can't really tell from this whether or not the trademark is for Diet Coke or if it's just for Coke. I don't know the answer.
Well, and I hear you speaking kind of to the whole thing of, can you talk a little bit about the difference between trademarking words and trademarking a design and some of the issues people got in thinking they thought they trademarked just any way they designed it, right? And they sent in a design and they got a design trademark.
Right. Well, typically when you're thinking of trademarks, you can do it in a number of different ways, as you said. The first trademark that you want to get is for just the block letter, just the word, whatever it is that you want to get that. Because if you think about any business that's out there, over years they start changing their logo, their icon that they use. It just develops and looks different. They use different script, or it's a circle around. Who knows what may go with it? So you want to, first of all, you want to control the words. So that's what you want to get your first trademark on. And you typically don't even have, in those situations, you can actually you can trademark the word Coke as just block letters Coke. So, just type in Coke and that's all that it is. And then you can use as your example this logo that you have here. So that's number one, is just the word itself. Then when you get into logos and you're working on logos, you're going to have to start describing them with a lot more specificity to the trademark office so that the logo becomes then the representation, not necessarily the word, but that representation itself becomes the trademark. And one's not coming to mind right now, but Microsoft with the four colored squares, is that something that they trademark, and you want that icon to become the adjective that says, oh, computer program, or describes a office suite, Microsoft Office suite, that type of thing. So there are differences between just the word and the logo. What you eventually want to do in marketing, and if you're heavy in marketing, is you want your logo to signify your word without even having the word in it. You want your logo to be there. So it becomes very important then, as you're developing your brand, is to come up with that logo that people recognize immediately and say, Microsoft.
And then another
Or
question.
here, Apple is even better.
Right. Yeah. So another question. So I'm a designer, and if I'm designing something, and technically I own the copyright, but I'm designing it for a company that I want to start running, do I need to do the whole transition of copyright from me to the business entity?
You may want to, or you may want to simply license it to your company. And that's another legal protection which can be added. But whether or not that's appropriate or necessary under any particular circumstance, you're going to have to look at how the business is going to be operated and what is their value in that you need to protect separate from the value of the business. Yes?
I was wondering, how easy is it for someone to invent something like similar to yours? If I invent something, would they be able to, and I patent it, would they be able to patent something similar if they just like change it a little bit, or how?
Well, patents are, I'm not a patent attorney, we'll start that off with, but patents are much more detailed and much more sophisticated than anything dealing with trademarks or copyrights. If it is, there are different kinds of patents also. There is I guess the invention or design patent, and then there's a utility patent. Design patent is what you were kind of talking about, where you design something that is unique and creative, hasn't been done before. Somebody comes along and just copies it, then more than likely the patent department is going to say, you just copied somebody else's patent. You don't get a patent, and in fact you're infringing, and that patent holder, if they didn't give you a license, you can't do it. On the other hand, a utility patent is you come up with a better stapler or a better paperclip. It's your paperclip is what we think of as a standard paperclip. Mine looks like a star. So I can get a utility patent on my paperclip. You can get a utility patent on your paperclip for it basically doing the same thing. It just looks different, and it may be made out of. I make mine out of plastic. You make yours out of copper. So there's differences when it comes there. But the more technical thing is if it's a unique design, and it's got to be a unique design if you're going to get a patent on it. If it's a unique design, then it's anybody that copies it is going to be infringing. Now, that doesn't mean that if somebody, this happens all over the world, somebody in China and Russia and the United States and UK are all working independently on the same concept. That's when you have to start looking into the scientific side of what do you do when you're designing and developing something. You're taking notes, you're putting together booklets, or taking, each day that you do something, you're recording what you've done. And the patent office will look for what is what kind of information is out there that you have to support, because you were the one that originally came up with this idea. I started developing this in 1948. You didn't start developing it until 1968. It turned out to be the same thing when you get to the patent office in the 90s. And who's going to end up getting the patent if they're effectively exactly the same thing? The person that started on it in 1948. So that's So then, yes, it can be done independently, but if it's just a knockoff, not gonna do that.
Let's say you're launching a product that has, a unique design, you patent that design, a design patent, and then a couple months pass by and that product, you're launching a new 2.0 version that has a new different kind of design, the same product with a different design. Can you then get a design trademark, like to protect yourself, or do you need to go again and get a full design patent?
Well, patents have nothing to do with trademarks, have nothing to do with copyrights, completely separate. So if you come in with a new way of doing something, a new design for doing the same thing that your old design did, just O2, you're probably going to want to patent it separately because if it's different enough, it's just a variation on your original patent, which would be fine, and you would still be able to control variation. But if it's something brand new again, then it's separately patentable, and you want to separately patent it so you can stop other people from copying your new design without paying for it.
Oh, so if it's a variation, in other words, with variation of your older product,
It's
you can still
probably
be
don't
covered
need a
in the
new
same
patent.
Okay.
Probably don't need it. It's just when you start
Depends how you
making
it.
it something more unique.
For me, my process is completely natural. I mean, it happens in nature all the time, so I can't patent that. So if you do a utility patent, to patent the process.
No, and this is, it can get very technical, and I'm not the scientist here, but if there's something unique about your process that no one else is doing, it's just that you've come together and you figured out how to do something that nobody else has done before. A couple of issues there. Do you really want to patent it and let everybody know how to do what you do? Or are you going to keep it as a trade secret, as proprietary information, not tell anybody else so that everybody has to come to you to buy the machine or whatever it is, because otherwise they can't do it.
If I patent it, then everyone will know what I'm doing.
Right, when you patent it, it becomes public knowledge. So they can go in and they can look at it, and hopefully it's unique enough to get a patent, but it could be, and I really don't know the process, but whether or not it's unique enough to actually get a patent, it's something that the patent office thinks is just common knowledge, and you're just putting two pieces of common knowledge together. They're probably not going to get a patent, but if there's something unique about the way that you came up with this that nobody else would have ever thought of, then it potentially is patent.
So I can patent the process of how I did it, but not the ratio of the output, like not the end material.
Material is there something unique about the material that other people could?